Ms. Mapes.
Good morning, Your Honors, Counsel. May it please the Court. Your Honors, this case comes before this Court following the Court of Appeals' determination that Robert Vaughan was denied a fair trial as a result of a conflict of interest in his pretrial counsel, John Henson. This determination is flawed and should be reversed. The Court of Appeals overlooked the importance of the District Court appointing new conflict-free counsel prior to trial. Now, the Court of Appeals applied the standard of Watson and, in the alternative, the standard under Mickens. However, the facts of this case do not warrant automatic reversal, nor do they establish an actual conflict of interest that adversely affected Mr. Henson's representation. In fact, the appointment of conflict-free counsel and the fact that Mr. Vaughan has already received the full extent of remedies available under our conflicts analysis demonstrates why application of these cases was inappropriate.
Do we need to decide whether there was or wasn't a conflict requiring new counsel when the fact is Vaughan got new conflict-free counsel well in advance of trial?
No, Your Honor. The fact that he did receive conflict-free counsel prior to trial makes a conflicts claim against his pretrial counsel moot because counsel was appointed prior to trial. In fact, he had almost 4 months to review Mr. Henson's pretrial investigations, depositions, and redo any of those activities that were found deficient. And so anything that occurred with Mr. Henson is no longer relevant, and the focus should be on his trial counsel.
I want to go back just for a second, just to maybe you can clarify for me. I seem to have a little bit of inconsistency about whether Mr. Henson was continuing to represent that witness after June 1st of that year. And I thought I saw that pretty much took care of things, but then otherwise in some of the briefs I thought there was ongoing representation in other matters. Which is accurate, just so I know?
The matter that Mr. Henson was originally handling with Mr. Klein had ended. He was there handling the guilty plea, and sentencing was completed before Mr. Vaughan's trial. But I believe another matter did come up, and the same public defender's office was representing him, although it wasn't Mr. Henson specifically.
And when did that come up exactly? Do you have a time frame for me? So June 1st, and then I think in August is when the motion to withdraw and is granted and things. Can you tell me?
I don't have the exact time of when that matter came up. I think there was part of the record did discuss that Mr. Klein had been in a halfway house, I believe, for a few months and was close to sentence before the issue came up, and so there was at least a couple months in between, but I don't have the exact dates available for that.
Does it make a difference that another public defender was there? Because we don't have screening in Iowa in those offices, and it would be just like Mr. Henson representing him. So, I mean, does that still create a problem if their office is actively representing him when Mr. Klein is testifying against Mr. Vaughan?
It doesn't impact Mr. Vaughan. Whether or not Mr. Klein feels there might be an issue with his counsel being tied to someone else is entirely separate, but the attorney who represented Mr. Vaughan at trial was not linked to that office, was not...
My concern is that an attorney who was representing Vaughan was now representing Klein and may have been able to give Mr. Klein some information to help him testify against Mr. Vaughan. That's my concern.
Well, we don't have any evidence of that actually occurring here. We would need to develop additional record to see if there was any communication between Henson and that other attorney.
But we don't have screening, so we, even if, it's imputed. The knowledge is imputed under our law unless it's, in other states allow screening. We don't allow screening.
So I don't believe that is a problem in this case because we already knew what Mr. Klein's testimony was going to be before that matter came up. He was deposed by Vaughan's new counsel prior to trial, and there didn't seem to be any major inconsistencies between that deposition and what he provided at trial. So we don't have any evidence to suggest that even if there was a conflict that I guess Mr. Klein's testimony was impacted by who was representing him in that. So there is no way to tie it to Vaughan's case and whether or not he was deprived of fair trial.
Is there a recurring issue out there that our court should decide whether the public defenders, service attorneys, are government lawyers under the rules such that the conflicts of one are not imputed to another?
I believe the state recently argued in McKinley that the public defender's office should not be subject to imputed conflicts, and that over time it would interfere with the public defender's office being able to represent clients, especially if it's a smaller community. So the state's position is that in terms of the public defender's office, these conflicts should not be imputed. So, in going back to the analysis that the Court of Appeals applied, first was Watson. However, the purpose of Watson was to require courts to conduct an inquiry when they knew or should have known of a particular conflict, and it held automatic reversal was necessary if they failed to do so. However, in this case, Mr. Henson did file his motion to withdraw, and the court granted it and appointed new counsel. At that point, no additional inquiry was necessary. So in this case, automatic reversal should not apply, especially since our courts have held that when some form of an inquiry does occur, even if that conflicted counsel is not removed, automatic reversal is not appropriate. In this case, Mr. Henson's withdrawal and the appointment of conflict-free counsel eliminated any risk of an inherent harm that threatened the fairness of Vaughan's trial. And so in that sense, the application of Watson was erroneously applied to this case. And the second part of their analysis focused on Mickens, and under that case, an actual conflict requires adverse impact on counsel's representation. However, at no point has Vaughan identified any specific portion of Mr. Henson's pretrial investigations or depositions that were negatively impacted. The defendant and the Court of Appeals placed undue emphasis on the 80 days that transpired between his interaction with Mr. Klein and his motion to withdraw from this case. However, at no point during that period was he aware of the substance of Mr. Klein's testimony. He was not laboring under any division of loyalties when he performed these pretrial duties.
And even if he was, in August, he's gone, and you now have conflict-free counsel. So why do we need to even address these issues about Mickens and whether there was an actual conflict adversely affecting Henson's performance when, as of August, Henson's no longer the lawyer, right?
That's completely correct, and that's the point that I'm getting to, is that the application of Watson and Mickens in this case wasn't appropriate because the appointment of conflict-free counsel places this case outside of our traditional conflicts of interest analysis, and instead should be focused on a claim of ineffective assistance of counsel, because once he had new counsel, that attorney had the opportunity to review what occurred and to take any steps to correct deficiencies. So if there is a failure in his decision not to redepose, that would be a claim of ineffective assistance, not a conflict of interest. And that is exactly why the Court of Appeals missed the point in this case. Judge McDonald was the only one that narrowed in on the importance of the appointment of conflict-free counsel. And even if we have issues with what Mr. Henson did, even if we personally would have taken different steps, that is irrelevant once there was new counsel in this case. To accept Vaughan's claim, we would have to make several pretty serious assumptions that just are not warranted under any of our case law. We would have to assume that first, Mr. Henson was not truthful in stating he was unaware of Klein's testimony. We would then have to assume that this knowledge somehow adversely impacted his representation, but there's no indication of any adverse impact, and there's no reason to believe that his connection to Mr. Klein would have any impact on how he deposed the firefighters, neighbors, and lead witness in this case. And then lastly, we would have to assume that his replacement counsel was ineffective in failing to detect and remedy these deficiencies. And our courts traditionally presume that counsel performs competently unless the contrary is established by the defendant. And Vaughan has not asserted a claim of ineffective assistance of counsel, and there's no evidence to support that claim based off of this record. The problem is that this situation was trying to be fit into the wrong analysis. This is not a conflict of interest. If anything, this is a claim of ineffective assistance of counsel, and that's not yet before this court. Unless you have any questions, the state respectfully requests that this court reverse the holding of the Court of Appeals and affirm the conviction of Robert Vaughan. Thank you.
Thank you, counsel. And Mr. Fisher.
May it please the court, counsel. My name is Mark Fisher, and it's my privilege to represent Robert Vaughan here today. The conflict of interest in the case at bar, I believe, is what's at the heart of this argument. I believe that it is an extreme example of a conflict.
Oh, let me ask you hypothetically. What happens if they had a Watson hearing early on, right before the attorney withdrew? You'd get that remedy of conflict-free counsel, wouldn't you?
Yes.
So why getting conflict-free counsel without the Watson hearing makes this reversible?
Well, Your Honor, I think that Your Honors, I think that the Watson hearing serves several purposes to explore the type of the conflict, and also could have addressed the ongoing state public defender's representation of Klein through the time of trial, which I do believe is a continued conflict, as Vaughan certainly has a right to the confidentiality of his secrets and to his confidential information. And
that's not a conflict anymore. That's the problem with that is, I mean, you're assuming that he would breach his ethical duty and somehow convey something to Mr. Klein that he should no longer convey. He no longer has he's no longer representing two people, so there's no longer a conflict in that sense. So in order for this to be a problem, you'd just have to assume he's going to breach his ethical duty. In fact, that would still be a problem today. He could go and see Mr. Klein and reveal confidential information now, but where's the basis for concluding that?
I think it does continue to be a problem because all the information is imputed to everyone in his firm, and I think that continued representation of the witness throughout the trial doesn't fully cure the conflict because it's continued to represent.
But after the fact, don't you show that that there was information given? I mean, before the fact, this court could order screening. We've done that in the past.
Yes.
That's out of the bag. So, you know, don't you have to show once it happens that there was some breach to show actual conflict? I mean, we can't assume that Mr. Klein received information from his prior attorney about Mr. Vaughan. I mean, you have to prove something. I mean, you just can't come in here and get a new hearing, can you?
Well, I think that the conflict affected the pretrial provisions, and no inquiry was made into what portion of the pretrial portions it infected. The 80 days that it lasted during depositions of firefighters and lead investigators, also during pretrial preparation and discovery, without judicial inquiry, there was no way to know when this conflict began.
Was there,
New counsel could have, new counsel, if had a problem, surely should have raised it and could have, right?
Yes, but without the judicial inquiry, the only information that was available on the form was a motion to withdraw, which recited that they had a conflict. The information that came out at the hearing and at the trial was that he had been that Mr. Klein had told Mr. Henson at the time in May 31st that he was the guy who tried to hire me to start that fire.
Actually, that's what the Henson denied that in the hearing that happened afterwards, and the district court found Henson credible on that point. Correct. So we have a finding that actually, that it's a constitutional question. So maybe we're not bound by it, but we should certainly at least defer to it. We have a district court finding that all Henson was told is that I want to talk to the prosecutor about Vaughan.
Yes, although Klein testified differently, and that's the witness the state put on for their case in chief.
let's assume that's all right, and let's assume you get a redo.
Yes.
All the stuff that was done by Henson is still admissible in the redo. I mean, all those depositions are going to be the same. All the pretrial work he does is available because the depositions and all that stuff's, part of the record, and you could use it in a subsequent hearing. So tell me, because the Court of Appeals didn't order a redo, without using all that stuff. So tell me how it makes a difference that there was something that was done that caused your client any prejudice to give you a redo without showing harm to your client. And that's my problem. Well, you're going to get another trial with a third conflict-free client, but all that other information still available to him.
Well, I think, as the Court of Appeals noted, it would restart the deadlines, and they'd have opportunity to do depositions of the witnesses that were previously deposed. I think that I don't think that Mr. Vaughan should be forced to show that there was prejudice. I think that this is a type of conflict where the court can presume that there was prejudice.
But not. I mean, I don't think you can presume prejudice after he gets conflict-free counsel, and he got it 4 months before the new trial. And looking at the record, it looks like new counsel spent a lot of time on the case. It wasn't that he exclusively relied on what had been done before. I think there are fee applications in there for well over 100 hours of pretrial work.
Yes, although the 80 days that passed where the conflict continued to exist, there hasn't been a showing that work was redone. There wasn't a judicial inquiry into that.
Well, maybe it didn't have to be redone. I mean, the conflict-free counsel, I take it, picks up the file, examines it, figures out what needs to be done, sees some things have been done, some things haven't been done. If there was a problem, conflict-free counsel would have approached the court and said, hey, we need to change this aspect, or I need to do this, or I need to do that. And frankly, the court, in light of appointment of new counsel, frankly, is likely to be pretty receptive to it. But that's not what happened. I mean, the conflict-free counsel examined the file, used, I take it, we can presume, I think, used independent judgment and decided it was adequate. No?
Well, I think that at any time when a conflict of this nature comes up and the court is aware of it, I think there should be judicial inquiry that informs the parties on the record of the conflict and what nature and the extent of what it infected, so that they can put measures in place to remedy any of the harm that may have been done. Here there was no action taken. It was just simply withdrawn and a new attorney appointed.
Counsel, can you point to any shortcomings in the depositions taken by Mr. Henson or any other that you could armchair quarterback, say he pulled some punches, or there's some indication of a problem or prejudice during that 80-day period?
I can't, and that's one of the reasons why I think prejudice has to be presumed in a case like this. Often the harm that's inflicted in types of cases is silent because it's not so much of what's done, it's what's not done or what not pursued. And I think that requiring a prejudice as the Supreme Court did in Mickens under their guidelines. I think.
Let me spin this out. So what you're saying is anytime in a criminal case, because these do happen, where the public defender's office says, we're going to withdraw because we would like to withdraw because we have a conflict, another lawyer needs to be appointed. And that does happen often, right?
Yes.
The court can't simply grant it. It has to bring the public defender in, it has to question the public defender, it has to bring in whoever the other individual is that serves as the basis of the conflict, question them. Is that your view? I mean, because
I think on initial, I think that the in those situations the client does have a right to be informed of the conflict. But in my understanding, what the court is talking about is often the public defender is appointed and immediately withdraws because of a conflict. In this case, the conflict existed for over 80 days. Mr. Henson was on Mr. Vaughan's case for a substantial period of time, getting ready for trial, doing depositions, and then at the last minute had to withdraw. I know the case was continued out and was moved forward so that new counsel could have time. But I think that under these scenarios, I think that a judicial inquiry is important and was required by the law.
What do you make of the Court of Appeals not prohibiting client from testifying in the new trial? I mean, so if you don't prohibit client from testifying in the new trial, what does that tell us?
Well, I think that unfortunately this is an area of law that doesn't have much case law in terms of asking for client's exclusion of testimony, so I don't think they felt they had the authority to, and unfortunately I have not found any authority. I think it would be the appropriate remedy given the way that his testimony was brought forward by his own defense counsel.
That's my question. What authority do you have for it? Because I couldn't find any either.
Right, and I couldn't find any, and so that's I just believe that it's a constitutional infirmity that makes the whole process, the integrity of the whole process and the verdict is questioned when defense counsel turns over the key witness to the state in this scenario. And so I think that undermines the confidence in the verdict and the judicial integrity of the whole system. I think that in the case like this where it's discovered that counsel was laboring under a conflict of interest for 80 days during pretrial procedure, conducting depositions, doing the stuff that's required for pretrial, I think that reversal should be mandatory and the court should follow Watson under the Iowa Constitution for good reason, and that being of judicial integrity and upholding public confidence. I think the Supreme Court was wrong in Mickens to get rid of the requirement that judicial inquiry be done based on an analysis of the deterrent effect on judicial officers, and so I would ask that Watson.
Going back to this remedy question, it wasn't the state's fault that Henson had a conflict of interest, right? I mean,
correct, and
but they're the ones that would be penalized by not having the witness at the retrial.
Right, but
Go ahead, I'm sorry.
No, right, but I don't think it's about punishment. I think it's about the integrity of the whole system. The state took the information and didn't inform the court or didn't inform anyone for, I believe, 60 days or so that they were going to call Klein, allowing the continued conflict to continue. So I think that that would be the basis for that, would be just overall fairness.
And I mean, if we apply some sort of inevitable discovery concept or something like that, I mean, is there really any doubt that if Henson had told Klein, I'll get you a different lawyer to talk to you, but I can't represent you any longer, that Klein would still have approached the prosecutor with the information about Vaughan?
I guess I have no way of knowing what would have happened. I don't know if he came up with it because Henson was the attorney and said he was working on Vaughan's case, or whether he would have sought out the police or the prosecutor on his own. I don't know. But I think that the nature of this conflict and just the overwhelming weight it had on the whole situation requires that the court consider it seriously and reverse.
I guess I have a question like I asked the opposing counsel in this matter. When did this conflict really develop? So you're saying that there was an immediate conflict once he's all done with Klein, and I think the record shows then that he was done representing Klein. Then he says, oh, by the way, I may have some information on Vaughan. Is that the trigger? Is that the conflict, even though I'm done representing him now? Is that the trigger? Or because the Court of Appeals rules that there's an actual conflict of interest. Now you're saying that it's really more of an implied conflict of interest, and then there's some type of concurrent conflict of interest. Where are we really saying the conflict developed? I mean, the triggering device is, hey, I've got something to say about Vaughan's case, and then
No, I do believe there was an actual conflict of interest as well. I agree with the Court of Appeals. On May 31st, 2012, Hinson met with Klein at the jail to execute a plea agreement. So it was still, as it was operating as his attorney at that time. And at that meeting, according to Klein told him that Vaughan is the guy who tried to hire me to set that fire. Would you please get me in contact with the prosecutor? At that time, Hinson proceeds to call on or about June 1st the county attorney and tells him, hey, Klein wants to talk to you about Vaughan, or to law enforcement, or words to that effect. At that point, I think clearly there's a conflict of interest.
Again, you're taking the version of this convicted felon of what the conversation was. Henson said otherwise. He just said, I was told that he wanted to talk to the prosecutor about Vaughan, which seems to me probably, even just kind of knowing how these things play out, maybe that's the more likely version of what happened. And so don't we have to accept the trial judge's version of what happened based on the hearing?
I don't think the court has to accept that. I think it's a de novo review. I think that even under Hinson's version, I think that it's an actual conflict at that time, because a seasoned public defender would know asking to talk to Vaughan was for the purpose of trying to talk about something about the case. And so I guess that conflict continues on. As I understand it, Mr. Klein continued to have cases with them for quite some time, and so it kind of continued on and on for that period. But I'm out of time. Thank you.
Thank you, Mr. Fisher. Rebuttal argument?
Your Honors, defense counsel focused pretty heavily on the need for additional judicial inquiry, but courts have routinely held that the only duty they have is to determine if a waiver is appropriate or if they need to remove counsel. Any additional steps that have to be taken from that point on are to be determined by the new counsel. That's not the role of the judge in this instance. And Mr. Vaughan had new counsel who was fully competent to make that determination and did so in this instance. He chose not to redepose any of those witnesses.
What do you make of the fact that was briefly talked about, and that is that well, actually there's a dispute of fact, but Henson called the prosecutor and indicated that Klein wanted to talk. How should that be treated? I mean, that's pretty extraordinary, quite frankly. I mean, for a attorney representing one client and then calling the prosecutor and saying, hey, there's somebody, I have another client who wants to talk to you about this event, that's pretty extraordinary. What's your reaction to that, and how should we regard that question?
Well, at that point, it wasn't clear to Mr. Henson what Mr. Klein was going to say or if it would turn out to be relevant. So at that point, it wasn't obvious that there would be a conflict of interest that would ultimately develop. And we do tend to defer to counsel to make the determination of whether a conflict exists that requires them to revert or to withdraw. And since...
Meaning, so the suggestion is that Henson didn't know whether the information would be exculpatory or inculpatory?
Or not, so it's unlikely that he would have provided beneficial information to Vaughan, although possible.
But if I'm representing someone in a serious felony, I don't want to give the prosecution ideas.
But at the same time, he does owe a duty to Mr. Klein, and if he wishes to speak to the prosecutor,
Well, At that point, he should have, I mean, wow, I mean, I guess I'm finding this a little troublesome, so I'm giving you an opportunity to get
Right.
right at it.
And this was a pretty big coincidence that the person he happened to go to did turn out to be the person who has information. But again, that isn't extremely relevant to our current analysis because all of that happened. He still performed the pretrial depositions and his pretrial duties without knowing whether there was a conflict. He was not laboring under a division of loyalties. And regardless, new counsel was appointed who...
Is there a strong basis in the record for assuming that the prosecution would have come up with this evidence in any event? I mean, we heard some talk, Justice Mansfield was referring to inevitable discovery.
Right.
What's the state of the record on that issue?
We do have Mr. Klein testifying to the reason for providing this information. He stated he wanted to give a better example for his children. He was trying to turn a new leaf, be a better person. So it is likely that he would have provided this information if Mr. Henson had said, I can't make that phone call for you, but if you want to speak with him, I'll provide someone else who can do that for you, or you can personally contact him.
But is that a plausible or reasonable interpretation of the evidence? As I recall, Klein had been sitting in jail for quite some time and hadn't taken any action to initiate this communication with the state about Vaughan's case. I mean, that doesn't that make it seem really suspicious?
Not necessarily. At that time, he may have been preoccupied with the reason that he was in jail. Maybe it just happened to not be his focus at that particular moment. But once Mr. Henson said that he was representing Vaughan, at that point, he did remember that this was ongoing. His attention was brought to the fact that the trial was going to be happening soon. He may not have known whether the charges had officially been brought or at what point he was going to be facing trial. So even though he had previously not contacted them, once he was made aware of the litigation going on against Mr. Vaughan, he likely would have taken steps from that point on.
I mean, the conflict arose, if we're going to play inevitable discovery, and I'm not sure we have to, but if we do, the conflict arises, potential conflict, actual conflict, whatever we want to call it, arises once Klein says to Henson, I want to go to the prosecutor and talk, I have something about Vaughan I want to talk to. So then, playing it out, if Henson had said, I'm going to have to give you another attorney you can talk to about that issue. And another attorney was appointed, assuming that could be done. Then the question is does the record suggest Klein would have passed the information through another attorney?
He was the one that initiated and said that he would like to speak to the prosecutor. So there is an inference that with different counsel that he would have still taken those steps.
Was there any reason to think that once he's chosen to come forward with this information, he would have changed his mind and withheld it just because Henson said he couldn't pass it on? Wouldn't he have just acted with the next attorney or on his own?
I don't think he would have changed his mind. I mean, especially if he had decided that he was trying to change his ways. It seems that he was pretty adamant about wanting to bring this information forward.
Counsel, I think that the state's argument seems to be that we don't have to worry about Watson because the facts of this case are different than Watson. But what rule are you asking us to follow on whether on when we apply the Watson presumption of prejudice and when we would not follow that?
I believe we, again, in McKinley, actually argued for Watson to not be viable under the Iowa Constitution.
But assuming that we maintain Watson, when in the future would we adopt it and follow it, and when would we not?
The language of Smitherman appears to be limiting Watson to the specific facts of that case, and In that case, there was not any form of an inquiry, and counsel did continue. And so in this case, the facts are very different from Watson. And so if we limit the holding of Watson, even under the Iowa Constitution, to the facts of that case, they certainly wouldn't apply here, where there was some form of a hearing in which counsel was withdrawn and conflict-free counsel was appointed. Thank you.
State versus Vaughan is submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.